name is Emily Sumner with Sumner Immigration. Today we are talking about 6 reasons that are invalid that people give not to naturalize. So again, 6 invalid reasons or excuses that people give not to naturalize. Again, my name is Emily Sumner with Sumner Immigration, and today that is what we're talking about. Thank you so much to everybody who's joining us live and to all of those who are catching us on the replay. If you have questions, feel free to put them in the comments, whether it's about this particular topic or another immigration topic, and I'm happy to answer as and when I can. So let's get into it. What are 6 reasons that people give that saying that they can't apply for naturalization that may not be true? So of course, before we begin, none of this information is legal advice. It's for educational purposes only, and you do need to talk to an immigration attorney because every case is different. One reason that I have heard clients give over the years that they cannot yet apply for naturalization is their green card is going to expire. Guess what? The rules have changed, and if you apply for naturalization, then you will receive a receipt notice for the N400 form that you file that indicates that your permanent residence is extended, or that your green card validity is extended for a period of 24 months while that N400 is in process. So that's not a valid reason necessarily to delay applying for naturalization. Another reason that I have heard people give over the years is that they do not want to give up their citizenship. That's a totally valid concern. I would feel the same way. But keep in mind that dual citizenship is a possibility for a lot of countries. It's not possible for every country, so it could be, depending on where you're from and what the rules of your particular country are, it could be that you would have to give up your citizenship. That is a possibility. But in a lot of cases, it is possible to hold US citizenship and citizenship of another country. That means that you keep both passports. And when you enter the United States, of course, you use your US passport. When you enter your home country, you use that passport, and then you can use them interchangeably like that. So in general, the United States, in terms of dual citizenship, our stance is it's okay with us if it's okay with the other country. So again, it depends on the rules of the other country, your home country, as to whether you can keep both citizenships and both passports, but it is a possibility. Keep in mind that there are some situations, like for example, India, where you technically cannot keep that citizenship and you would give up the passport, but they have something called Overseas Citizen of India, which is different from just not having Indian citizenship at all. It's not citizenship, but it's a way to ease that process. So keep in mind there might be something in the middle, depending on your country of citizenship. Another reason I've heard people say that they cannot apply for naturalization is that they have a criminal charge. And honestly, it might be true that you have a criminal charge that prohibits you from applying for citizenship. However, it's absolutely something to look into. Almost every week, maybe that's an exaggeration, but regularly we file citizenship applications, naturalization applications for clients who have criminal charges, whether they were convicted of it, whether they pled guilty, or whether it's dismissed, all different situations. But it is possible, depending on the situation, to apply for citizenship even though you have a criminal charge in the past. Good moral character is one of the 3 primary requirements of naturalization, and the look back period is 5 years or 3 years if you're married to a US citizen. USCIS can look further back than that. So that's something to keep in mind. Just because you have a criminal charge that was more than 5 years ago doesn't mean that you're off the hook and that you can definitely apply. So if you have a criminal charge, again, whether it's been expunged, whether you pled guilty or not, whether it was dismissed, whatever the situation is, if you have a criminal charge, absolutely talk to a qualified immigration attorney before applying for naturalization, because it can land you in hot water. There's some offenses that are deportable offenses, actually. And so not only would you not have naturalization approved, but you could land in removal proceedings, not the intended or desired outcome, obviously. So definitely talk to an immigration attorney. But like I said, regularly we file naturalization applications for clients who do have a criminal charge. The 4th reason is that clients or prospective clients say, I owe taxes, so I can't file. So the fact, the question of whether you have filed tax returns and whether you owe taxes, it does go to the question of good moral character, which, like I said, is one of the 3 primary requirements for naturalization. However, we have filed over the years for many clients who, yes, they owe taxes to the IRS, but they have they're on a payment plan and they're able to document that they have made regular payments to the IRS and it has not been a problem for naturalization. Again, every case is different, so make sure to talk to an immigration lawyer before you proceed if you have this particular situation, but it is something that you can potentially overcome. Reason number 5 is that you don't speak English well enough. I can't tell you how many people I have talked to over the years who are shy about their English language skills, and that's totally normal. I know speaking in a foreign language, I'm a Spanish major myself. I know speaking in a foreign language can be difficult. You can, potentially not feel confident about it, but don't necessarily let that prevent you from applying for naturalization. Number 1, there are a couple of exceptions depending on your age and how long you've been a permanent resident of the United States that would exempt you from the English language requirement. But moreover, the vast majority of people that I've talked to that say, I don't speak English well enough to qualify, they actually do. I will say, okay, let's just have a quick conversation, in English, just to see how things go. You don't have to understand somebody a native English speaker who's speaking as fast as they possibly can. I have trouble understanding that. And of course, they're all different English accents, whether we're talking about American or other accents, even within the United States. Anyway, my point is that you do not have to be fluent in English, but you do have to be conversant in English. So it is possible to ask the immigration officer at the interview to speak more slowly or to repeat their questions. The reading and writing that you have to do as part of the naturalization exam is typically on a 5th or 6th grade level. So it's not, PhD level writing and reading that you have to do in English. It is a more reasonable standard. And, sometimes there are situations where I say, you know what, you need to work on the language a little bit more before you apply. So certainly it can be a concern, but a lot of times it's more of a self-confidence issue than actually an issue. And we have clients who apply and they pass with flying colors. Finally, number 6 is sometimes clients or prospective clients will say, I don't meet the 5-year requirement yet, so I can't apply yet. Well, maybe. That is something that you have to be cognizant of, both the physical presence requirements and the continuous residence requirements. So in general, you have to have been a permanent resident for at least 5 of the past 5 years. You have to have been a permanent resident for at least 5 years. And you have to have been physically present for at least half that time, and you have to have continuously resided in the United States. We have a separate video on the differences between physical presence and continuous residence. But for the question of 5 years, keep in mind, if you are married to a U.S. citizen, married to and living with a U.S. citizen, you only have to have been a resident for at least 3 years. And that can include, if it's your situation, that can include the 2 years of conditional residence. So let's say that you apply for a green card. When it's approved for a conditional residence because you've only been married, you've been married for less than 2 years at the time that you received the green card. You timely submit the I-751 to remove the conditions. You may only have to wait another year before you apply for naturalization. Like I said, if you're married to and living with a U.S. citizen. And that's something that our clients do all the time. We will file the I-751, and then a year later, we file the N-400 application when they meet that 3-year mark, or at least 90 days before they meet that 3-year mark, and they qualify for permanent residence because, again, you only have to, or they qualify for naturalization. Because if you're married to a U.S. citizen and living with them, you only have to wait 3 years instead of 5. In addition, one nuance there that some people may not know, is that in that situation, if you have the I-751 petition pending, it does not have to be approved before you submit the N-400 application. You can submit the N-400 application for naturalization while the I-751 is still pending. And when the officer gets the N-400 and to adjudicate it, they will adjudicate or process the I-751 at the same time. So it kind of speeds up the I-751 processing, which is nice. So something to keep in mind. The other thing to keep in mind with that rule that if you're living with a US citizen and married to a US citizen, you only have to wait 3 years. You don't have to have received your green card based on marriage to that US citizen. So you could have received your green card through, for example, the employment-based process, and then be married to a US citizen and living with them for 3 years and still meet that requirement and still file on that basis. You still have to show that it's a valid marriage if you file on that basis, but it is absolutely possible. And then I have a bonus tip. This is actually number 7. My bonus tip is sometimes, or my bonus kind of reason that people give is it takes too long. Right now, it is not taking too long. So I'm speaking in October of 2024. Right now, it is not taking too long. It depends on a number of factors. Of course, cases can get stuck, certainly. But honestly, from the time right now, and it's been like this for a couple of years, from the time we file to the time that the clients have the interview is typically about 3 to 4 months in our particular area right now. We have clients all over the country, and that's not at all uncommon. It's not guaranteed. Of course, it's subject to change. It does depend on the specific case and the specific location, but it's taking about 3 to 4 months. We just received an email today from an individual, a client, who had their interview today. They were sworn in. Some offices are able to swear in the same day. He was sworn in today as a US citizen. This is October 29th. We filed his case in July of 2024. So not only is he sworn in, he's a US citizen, he's able to apply for the passport, but he is registering to vote today. In his particular state, that's still a possibility in time for the election. So don't let that be an excuse for you that it takes too long, because this is not one of those immigration processes that takes years and years and years to go through. It goes pretty quickly. So those are 7 reasons that people give, that, reasons that they give that they say they can't apply for naturalization right now, that really could be invalid reasons. There really could be a way to do it even though you have these concerns. I hope that you have found this information helpful. If so, I hope that you will share this video with a friend or a colleague, and make sure that you subscribe to our channel so you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world with employment-based and family-based immigration matters. I hope that you will join us again live next Tuesday for Live at Lunch Tuesday at noon Eastern. Until next time.